SwayamPrabha. Digital India. Educated India.
I am Devojit Kumar Sharma. I will be teaching this particular topic on juvenile justice as part of the course on criminology, penology and victimology. When we talk about juvenile justice, first and foremost the things that may come to your mind, why do we call it juvenile justice? Because we already have a system in place that is called as criminal justice system. If we have the criminal justice system in place, what was the need to have a separate system altogether, which is called as juvenile justice system? This is the fundamental question which often come to everyone's mind, the need and relevance of having a separate and a distinct system for juveniles. To understand that, we may have to delve into the very philosophical underpinnings of the system of juvenile justice. The philosophical underpinnings of the juvenile justice system are quite different and distinct from that of the criminal justice system. So far as the criminal justice system is concerned, the philosophical underpinnings are predominantly deterrence, retribution and so on and so forth. But when it comes to juvenile justice, please understand the very approach and the philosophy cannot be deterrence and retribution, rather it has to be something called as reformation and rehabilitation of offenders. This is because of that very philosophical distinction that we have a separate system, what is called as juvenile justice system. Though the terminology being used here is juvenile, but appreciate the fact that this terminology also includes children who are in need of care and protection. So far as India is concerned, as you all may be knowing that we have this central legislation called as the Juvenile Justice Care and Protection of Children Act 2015, which is in operation or which is enforced in the country as a whole. Now, this is a central legislation and all the states, union territories are governed by one central legislation, that is the Juvenile Justice Act of 2015. But it was only in the year 1986 when the country had the first Juvenile Justice Act, then we started having uniform legislation for the entire country. Prior to that, we used to have Children's Act specific to specific regions, not necessarily a central legislation for that purpose. Even though we had something called the Children Act of 1960, which was a kind of first model legislation based on which different states they started having their own separate and different Children's Act altogether. Now, in this particular backdrop, we need to delve into or we need to look at the very operational parameter of juvenile justice system in the country. Whatever I have just narrated to you, if I have to put those ideas into one cohesive order, it will be like, number one, when it comes to juvenile justice, it generally refers to laws governing children committing offenses. However, JJ has always taken note of the fact that children in need of care and protection are also to be covered or governed by the same legislation. Now, another obvious question which may come to your mind, why is it so? Why is that same law should also take care of the children who are in need of care and protection? The answer would be that it is the same set of children who need care and protection. They may be the potential people for commission of crime in future. To prevent such tendencies among children who may be neglected ones, who may be the destitute one, it is important and imperative that the same set of legislation, that is the Juvenile Justice Act, ought to take care of not only children who are in conflict with law, but also children who need care and protection. The first legislation so far as children in India was the Apprentices Act of 1850. It applied to children who were below the age of 15 years, found to have committed petty offences and etc. Now, it for the first time gave a different or differential treatment towards such children, and the next important development in the history and evolution of juvenile justice can be said to be the Reformatory Act of 1898. Now, what was all about Reformatory Act? It is again children below the age of 15 years were sent to the reformatories rather than being sent to the jails or the prisons for that purpose, but if only found suitable. That means, from the Apprentices Act of 1850 to 1898 Reformatory Schools Act, more or less the philosophical backdrop remained the same. There was an understanding that children required reformation. Next came the Children Act of 1920. Now, what happened here was, I cannot call it a kind of singular legislation for the country as a whole. That is why I have said that Children Acts of 1920. What does it imply and mean to you students? It means that different states in India, they started enacting their own Children's Act, from the year 1920 and the subsequent years altogether. Now, the Children Acts of different states, they included neglected children and also children who were the kind of delinquent children at the term that time it was known to be. Now, it also laid emphasis on segregation of children accused of committing offences. Now, after that, the important development in the whole evolution of juvenile justice system in India was the Children Act of 1960, about which I have just discussed with you. It was a kind of model legislation, and it was for the first time in the Children Act of 1860 that the age of boys was fixed at 16 years, and so far as girls were concerned, it was fixed at 18 years. And it also mentioned, or it empowered the states to establish or set up something called as Children's Court. And this Children's Court primarily catered to the requirement of both delinquent as well as neglected children. Now, after this important phase of development which happened in India, there came one important, I would call it an first uniform legislation, as I have mentioned to you earlier, that was the Juvenile Justice Act of 1986. It was applicable throughout the whole country. Now, in this particular point of reference, may also take you to another important legislation which was enacted in India in 1958, that is called as the Provision of Offenders Act 1958. That means Juvenile Justice Act of 1986 came subsequent to the passing of the Provision of Offenders Act, and in the Provision of Offenders Act, you would notice that section 6 talks about releasing offenders under probation if the person happens to be below the age of 21 years. That means Section 6 of the Provision of Offenders Act imposes a restriction for every court in the country to imprison any person who is below the age of 21 years if the offense for which the person is being convicted is not punishable with life. That was already there. So, till the time this Juvenile Justice Act of 1986 was enacted, things were more or less governed by another legislation, that is the Provision of Offenders Act of 1958. But then please understand and realize there is a very important distinction between these two legislation, though they are grounded on the same reformatory kind of philosophy altogether, and that distinction is that though the Provision of Offenders Act also happens to be a central legislation, but the enforceability was somewhat different. Now, difference is that it was for the states to notify the application of the Provision of Offenders Act in their respective states. But so far as Juvenile Justice Act is concerned, it is for the central government to notify. That is why, though we have had this particular law, that is the Provision of Offenders Act enacted in 1958 itself, but then different states were having their own provision laws applicable to their own states, and not necessarily that every state they made notified this law on probation to their states or the parts of the state. Because of that, I would call it a drawback, or that aspect of the Provision of Offenders Act, perhaps there was another very important and emergent need that the country required an uniform legislation on the subject of juvenile justice. And there came the Juvenile Justice Act of 1986, and influenced by the Beijing rules that you all may be aware about, that the juvenile justice system in India is being influenced and impacted not only by the constitutional provisions which are there, which requires us to give a special and different treatment altogether to the children. We have the articles in the constitution which requires the states to give a special treatment to the children, but in addition to that, we have numerous international instruments which also want us, or which in fact mandate us to give somewhat differential treatment to the children, irrespective of the fact whether the child is in need of care and protection, or the child requires, or kind of some treatment or reformation after being found guilty of having committed an offense. Now, one of those important international instruments being the Beijing rules and the Juvenile Justice Act of 1986 can be largely said to have been influenced by the Beijing rules, and that is the reason why precisely the word juvenile was substituted by the word child in the Juvenile Justice Act of 1986. Or rather, I would, if I have to put it the other way, the Beijing rules substituted the word child by juveniles, and they came to be called as neglected juveniles. Now, again, when we will look at our present legislation for that purpose, that is the Juvenile Justice Act of 2015, you will notice that we do not use or make use of the word neglected juveniles anymore. We in fact do not call them juveniles, but ironically, if I have to put it, that though the very enactment or the legislation is called as Juvenile Justice Care and Protection of Children Act, but then the word juvenile is being defined also in the legislation, but then when it comes to the offenders, we stop calling them juveniles. and we rather call them children in need of care and protection. The reason is very simple. What I have just narrated to you in the beginning, that the approach toward children has to be different from that of the adult system or the criminal justice system, because the moment we call them juveniles, there is a kind of stigmatizing effect over such children. They might feel that we have been labeled as wrong people. There is a Howard Becker's labeling theory of criminology that you may be knowing about, which deals with the aspect that the moment we start labeling people as wrong people, they also tend to consider themselves as wrong, and eventually the probability is very high that such people are going to commit similar crimes more in number. And importantly here, friends, when it comes to children, they may not be knowing about different implication or the repercussion of the works or the different offenses they commit. That is why if we start calling them as wrong people or as juvenile, as delinquent, that would definitely or invariably leave a very negative impact in the young minds. And this can also lead to or lead them to commit crimes in future as an adult. So, the point I am trying to bring to your notice, or I am trying to explain to you here, is that we no more make use of such terms which we often use in case of criminal justice system. Now, with that came our kind of Juvenile Justice Act 2015, which has got altogether 10 chapters and 112 sections, 112 sections. But friends, before the coming of the Juvenile Justice Act of 2015, there are two important amendments that happened to the Juvenile Justice Act, which was enacted in 1986, and the first amendment was the Juvenile Justice Care and Protection of Children Amendment Act 2006, and then there was the Juvenile Justice Care and Protection of Children Amendment Act 2011. And even prior to that, one particular important legislation that I perhaps missed out here after the 1986 Juvenile Justice Act was Juvenile Justice Care and Protection Act 2000. Now, this important development perhaps I skipped in my discussion just now. This Act of 2000, it is so important that it has made the uniform age criteria of 18 years applicable to both boys and girls for the first time. Now, please understand and appreciate the fact that the Juvenile Justice Act of 1986 made two differences between boys and girls so far as the age is concerned. So, that means for boys it was 16 years, for the girls it was Children Act of 1960 for the first time, then came the JJ Act, now this of 1986, but with 2000 Act of Juvenile Justice, what happened was that for the first time the uniform 18 years was made as the cutoff age both in case of boys and girls. That was, you can call it as a paradigm shift in terms of equal treatment to both boys and girls so far as juvenile justice system in India is concerned. And why was it done? That is again another interesting story altogether, because we also India ratified something called the Child Rights Convention. In conformity with the Child Rights Convention, that this definition of child was made uniform as at 18 years. And please understand that the 18 years is still retained as the age criteria for children even in case of Juvenile Justice Care and Protection Act 2015. The Juvenile Justice Care and Protection of Children Act 2015, it was notified on 31st December 2015. So, that was the day when the Juvenile Justice Act was notified in the Gazette. But please understand that at that point of time, Juvenile Justice Act of 2000 was already in force. Now, does it mean that the day the 2015 Act was notified, it came into force replacing the earlier law on juvenile justice system? The answer is no, because there is a difference between a legislation being notified in the official gazette and a legislation being coming into force. We will come to that in the subsequent section in the Juvenile Justice Act, which says that this act will come into force on such date as the central government notifies. That means, the day something, a law is notified in the official gazette need not be the same date that the act would automatically come into force, and that is the story with Juvenile Justice Act also. Now, let us see what this law talks about at the beginning or in the preamble of this, in the preamble itself, and I read it for you. An act to consolidate and amend the law relating to children alleged or found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, by adopting a child-friendly approach in the adjudication and disposal of matters in the best interest of children and for their rehabilitation through processes provided and institution and bodies established herein under and for matters connected herewith or incidental thereto. So, the words which need to be understood by us very carefully, the first in this particular section, in the particular provision, what you find here is that children alleged and found to be in conflict with law. That is the very framing of the words that you find mentioned in the beginning of this law. Children who is alleged, that means they need not be actually the ones who have been found guilty, but then they have been alleged to have committed or not even committed an offense. This is the terminology we make use of in case of criminal justice system, in case of adults. But what they have deliberately made use of this word is who have been found to be in conflict with law. We do not call them accused, we do not call them convicts, we simply say that they have been, it is alleged that they have been found to be in conflict with law. Try to understand the approach that changes, and let me also bring to your kind notice here is that Juvenile Justice Act 2015 is not only the kind of something one legislation that is important, but it is also an outcome of lot of efforts that went into in making this law by the civil society groups and the groups which have been working in India for the protection of child rights. And another important term which is again you find mentioned, children in need of care and protection. The beauty lies here that nowhere in the very preamble of this law we make use of derogatory words against, be it the children who are in conflict with law or be it with the children who need care and protection. Now, in this provision of law, it is also stated that catering to their basic needs through proper care, protection, development, treatment and so on and so forth. But on a critical point here, let me inform you that the words such as protection, development and care have not been defined in the Juvenile Justice Act, though these have been used. This is again is a matter of discourse for us. Without the words being defined, if these words are being used, what would be the important connotation of these words altogether. Now, the subsequent provision in chapter 1, it is stated that whereas the provisions of the Constitution confer powers and impose duties under clause 3 of article 15 and clause E and F of article 39 and article 45 and article 47 on the state to ensure that all the needs of children are met and their basic human rights are fully protected. This is the point that I try to inform you in the very backdrop of this discussion, that the juvenile justice system in India is premised not only on the international instruments which have immensely impacted upon it, but also it has been influenced by the very promises that we have in the Constitution to give special and differential treatment toward children. Now, this preamble also talks about the fact that India ratified something called Child Rights Convention in 1992 and which has also prescribed certain standards to be adopted by all countries which have ratified that, and India is just one of those nations to have ratified this CRC or the Child Rights Convention. Now, coming to the subsequent provision which talks about the fact that India ratified not only CRC, but also UN standard minimum rules for the administration of juvenile justice, that is 1985 Beijing rules, about which I have already narrated to you, and also you have the UN rules for the protection of juveniles deprived of liberty 1990. Then you have Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption 1993 and other related international instruments. Now, all these international instruments or the parameters have been adequately taken care of for the purpose of the enactment of Juvenile Justice Act. Though the discussion today would be focusing more on the children in conflict with law, because that is the manner in which we have kind of conceptualized this particular lecture, but we also need to take cognizance of the fact that this legislation caters to the requirement of not only such children, but also children who need care and protection. That is why things such as adoption, things such as non-institutional care are coming into the picture, and in fact, in the very beginning of the act itself, it has been categorically mentioned altogether. One point that I have told you just before some time was that in the year 2015, 31st December, this act was notified. Whereas, if you look at section 1, subsection 3 of the act, it says, and I quote for you, "It shall come into force on such date as the central government may by notification in the official gazette appoint." And therefore, the date that we find of the present juvenile justice system or act rather to come into force was 15th January 2016. That is the important difference that we find in case of the Juvenile Justice Act, that it came into operation on this particular date. When we look at the juvenile justice law which prevails or which governs the country at present, it is important for us to look at the scheme of the act. And when we say the scheme of the act, important provisions of this act which deliberates or which gives us a clear picture of the system which is in place. That means, what is the functioning of the system? In what manner the system has been outlined in the scheme of the act is very important for us to know and understand. And for that, we may have to look at the important provision. I would like to inform you here is that this particular lecture pertains to understanding on juvenile justice system more particularly. That is why I have picked up those important provisions which are directly or indirectly talking about the children in need of in children who have been found to have committed wrong, or who are, rather the terminology being used is children who have been found to be in conflict with law. Now, the definitions under the Act are very important. For the purpose of an interpretation of any of the subsequent provision of the Juvenile Justice Act, the definitions which are found mentioned in this Act would be only used, or they will be only required. If there is some other definition given in some other law, that will not be applicable so far as juvenile justice system in India is concerned. Now, for the first time in the 2015 Act, what we find that they are mentioned about 3 important varieties of offences which can be committed by children. To put it in simple words, the Juvenile Justice Act of 2015 mentions that children can commit petty offences, children can commit serious offences, and children can commit heinous offences. And definition of what is petty offence, what amounts to serious offence, and what may amount to heinous offence have been given in this very definition clause of the Act itself. Because as we go on looking at the important provisions of this law, we would realize that in case of children of the age of 16 to 18 years, if they have been found to have committed a heinous offence, that is the important change which was brought into this present legislation after the infamous Nirvaya case which happened in Delhi, that 16 to 18 years, these children, if they have been found to be in conflict with law, but if the offence happens to be a heinous one, they will not be, they will not be taken care of by the Juvenile Justice Board, or their cases will not be dealt by the Juvenile Justice Board, rather it will be sent to the children's court, which are there in the regular criminal justice system. There is a huge controversy surrounding that. Now, how it is done, we are going to look at that aspect also, based on a preliminary assessment being done by the Juvenile Justice Board. If they consider it appropriate that such children need to be tried by the regular court, and in the regular court the terminology being used is children's court, such children can be dealt by the children's court rather than being dealt under the juvenile justice system, that is the Juvenile Justice Board. That aspect maybe we will look into it separately and after some time. Now, definitions of child in conflict with law, child in need of care and protection, child welfare officer, children whom, everything is there in the very definition clause of this Juvenile Justice Act 2015. The children's court definition is important for you to look at, and this is something that we find mentioned in section 2 subsection 20. It means a court established under the Commissions for Protection of Child Rights Act 2005, or a special court under the Protection of Children from Sexual Offences Act 2012, wherever existing, and where such courts have not been designated the court of sessions having jurisdiction to try offences under the Act. That is the definition of children's court that you find mentioned in the Juvenile Justice Act of 2015. Now, another important definition which you will find is District Child Protection Unit. This was not there in the earlier Juvenile Justice Act. Now, district child protection units are to be established by the district or rather established by the state government in every district for the holistic care of children. And there is something called ICPS, Integrated Child Protection Scheme, which was a kind of understanding between the central government and the state governments for the integrated services to the children in their respective states, including the children in need of care and protection and children in conflict with law, and resultantly total 589 district child protection units have been established or set up in the different districts of the country as an outcome of this ICPS agreement that was signed somewhere in 2009 or 2010. So, the definition of district child protection unit is also mentioned in the definition clause. I just told you that the Juvenile Justice Act talks about or it defines heinous offences, petty offences and serious offences. So, let us see what is the definition of heinous offences. It includes the offences for which the minimum punishment under the IPC or any other law for the timing in force is imprisonment for 7 years or more. That means, those are the heinous offences for the purpose of Juvenile Justice Act if the offence for which it is punishable is more than 7 years. That means, in the usual sense of the term, above the level of Chief Judicial Magistrate, above the CJM level, these are the sessions cases in the regular criminal justice system. Now, those are called as heinous offences, punishable with more than 7 years of imprisonment. Next important is petty offences. How is it defined? It includes the offences for which the maximum punishment under IPC or any other law for the timing in force is imprisonment up to 3 years. That means, not very serious cases which are punishable for not more than 3 years altogether. Now, the definition of serious offences and see the manner in which these 3 categories of offences are being outlined in this act is very interesting altogether, because such definitions are even not to be found in the Indian Penal Code. There is no such demarcation of offences, and also I would like to inform you is that unlike the Indian Penal Code of 1816, which does not prescribe community service as a mode of punishment, the very magnanimity of Juvenile Justice Act of 2015 is that it talked about or it prescribed community service as a mode of punishment also. And today what we are going to have is the new penal code, that is the which is going to come into effect from 1st July 2024. The new penal code is including community service as one of the types of punishment, and this is already there in the Juvenile Justice Act. That is one of the punishment is prescribed. Now, coming to the very definition of serious offences, it includes the offences for which the punishment under IPC or any other law for the timing in force is minimum imprisonment for a term more than 3 years and not exceeding 7 years, or maximum imprisonment for a term more than 7 years, but no minimum imprisonment or no minimum imprisonment of less than 7 years is provided. In such cases, one can call it a serious offences or serious offence. Now, the chapter 3 of the Juvenile Justice Act, it discusses or it kind of mentions about the very system of Juvenile Justice Board, what is the composition, what would be the qualification and the conditions of service of the people who are going to comprise the Juvenile Justice Board. As you may be knowing that there is somebody called the principal magistrate, and the principal magistrate of the Juvenile Justice Board has to be supported by other members, and interestingly the Juvenile Justice Act of 2015 also requires to have child psychologist as one of the members in the Juvenile Justice Board, and that is the reason I have told you that the preliminary assessment, what has to be done for the purpose of determining whether a child in the age group of 16 to 18 has committed a heinous offence has to be ascertained or certified by the child psychologist. Also, there are Supreme Court decision on that, the need to have child psychologist in house, that means within the Juvenile Justice Board. If not, the court has also ruled that the Juvenile Justice Board should get such expert opinion before declaring a particular child to have committed heinous offence, so that such a child can be sent to the regular court for the regular trial. Now, the subsequent section, section 6 talks about placement of person who committed an offence when person was below the age of 18 years. Then you also have section 7 which talks about procedure in relation to the board. What kind of procedure needs to be adopted? Please understand that the procedures to be adopted by the Juvenile Justice Board have to be child friendly, have to be keeping the best interest of the child. That is the very philosophical underpinning which has to be a kind of adopted by the Juvenile Justice Board or the CWC, that is Child Welfare Committee, throughout all the processes to be followed so far as Juvenile Justice Act is concerned. Now, chapter 4 of the Juvenile Justice Act talks about procedure in relation to children in conflict with law, and interestingly, section 10 of this act, which talks about apprehension of child alleged to be in conflict with law, mentions that no child would be kept or to be kept in jail or police lockup. That means, a child who is alleged to have committed an offence, or rather alleged to be in conflict with law, shall be placed in police lockup or lodged in a jail. That is one of the very important thing to be noted, because it reflects or gives an idea how the approach has to be different in case of children from that of an adult. Now, the state governments can make rules or provide for the manner in which such children may be sent to the observation home or any place of safety for that matter. These are what is being laid down as so far as the procedure in relation to such children are concerned. Now, bail, so far as such children is concerned, is laid down that a person cannot be denied bail who is apparently a child and alleged to have committed a bailable or non-bailable offences. The person should be released on bail with or without surety or placed under supervision of a probation officer or under the care of any fit person, provided when such person is not released on bail under subsection 1 by the board, it shall make an order sending him to an observation home or a place of safety, as the case may be, for such period during the pendency of the inquiry regarding the person as may be specified in that order. That means, in such cases of children, the bail is something that is usually given. In case the board declines to give the benefit of bail, such a child has to be sent to the observation home or the place of safety, and this definition of observation home and the place of safety are what is being laid down in the definition clause itself. The inquiry, so far as Juvenile Justice Board is concerned, has to be completed within the period of 4 months from the date of the first production of the child before the board. That is important. That means, there is a time limit which is being laid down, so that such cases are decided as expeditiously as possible without being detrimental to the very best interest of the child. Similarly, in case of heinous offences, what we find here is that preliminary assessment has to be completed within 3 months from the date of the first production of the child before the board. These timelines are important because it helps or supports the child to be not in that mental trauma or the fear of similar processes to be prolonged, because sooner this process is over, better for the child or on the part of the child, because the child would be free from such kind of apprehensions or tensions whatever because of such processes which may be going on in the Juvenile Justice Board as I have already stated. Now, in case of heinous offence, that is the most important thing, which is alleged to have been committed by child, and the child who has completed or is above the age of 16 years, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such crime. And it is also being provided in the explanation that the preliminary assessment is not a trial, and it should not be construed to be trial, but is to assess the capacity of such child to commit and understand the consequences of alleged offence. Because the understanding is that children may not be able to understand the implication or repercussion, but aftermath of the Niribhaya case, it has been found that there are cases of children of the age group of 16 to 18 years committing heinous offences who may be able to understand the consequences of that, and this preliminary assessment is meant to assess that. But since this preliminary assessment is part of the law, this present law, this has also raised to different controversies and debates, because whether the very fact of preliminary assessment leads to the violation of the rights of the child, because the principle governing the whole justice system is that the person should be presumed to be innocent until proven guilty. Now, if we apply the same principle, and that has to be declared by the court that the person is guilty, but in case of children, what we are doing is we are giving an assessment even before the child is finally found to have committed any wrong. Now, whether that is something that goes against the very fundamental principle of justice. Secondly, it is important to recognize here is that what the child requires is the care and protection. Is it something that goes counter to the Child Right Convention of convention to which the India ratified? That means the fact of segregating children into two compartments, that is, one who have committed heinous offence of the age of 16 to 18 years, and those below the age of 16 years who have committed such offences, whether it goes counter to the very philosophy or very principle that is enshrined in the Child Right Convention, that is another controversy. That means, to summarize, it can be said that whether similar arrangement of preliminary assessment goes counter to the very premise on which the juvenile justice system is being established in India, that is something for us to debate and discourse upon. There have been rulings of the Supreme Court that I have told you. Now, this assessment has to be done with the support of the child psychologist for that purpose, and if not done, that has to be arranged, because otherwise there is every possibility that such assessment may become subjective, and such subjective assessment may be counterproductive or may be detrimental to the very interest of the child. That is something that we need to take care of. Now, there are different orders, we do not call them punishment, we call them orders regarding child who is found to be in conflict with law, which are being laid down in the Juvenile Justice Act, which includes admonition, group counseling, community service, fine, paying of fine, and so on and so forth. You can just look at the relevant section. Now, the powers of the Children's Court, about which I have briefed you, is being laid down in the Act in section 19. Now, the Children's Court also have to adopt a very child friendly approach, considering the special needs of the child, tenets of fair trial, and maintaining a very conducive atmosphere for such cases of heinous crimes which are reported to the Children's Court. Now, the children court shall also ensure that child who is found to be in conflict with law is sent to a place of safety till he attains the age of 21 years, and thereafter the person shall be transferred to a jail. That means, up to the age of 21 years, no person can be sent to the jail. Rather, it requires that children's court will only send them to the place of safety in case the heinous offence is being proved by such courts. And after that, after attaining the age of 21, such children can be sent to the jail for that purpose. That is what is being laid down in section 19, subsection 3 of the Juvenile Justice Act 2015. Now, another important section is 21, which says that no child who is in conflict with law shall be imprisoned or sentenced to death or will be awarded life imprisonment without possibility of being released for any such offence, either under the provisions of IPC or under any special law for that purpose. That means, children cannot be given death penalty or life imprisonment as a matter of rule, what is being laid down in the Juvenile Justice Act of 2015. Now, one can appeal that the whole the scope of appeal is very much there. It is being laid down in section 101 of the Juvenile Justice Act. In case of someone who is aggrieved by an order made by the committee or the board, appeal shall lie to the children's court. In case a person is aggrieved with the order of the children's court, one can file an appeal in the high court in accordance with the procedure what is being laid down. Now, an appeal shall also lie against an order of the board. This is something very important and interesting to be looking into, passed after making the preliminary assessment into a heinous offence under section 15 of the Act before the court of sessions, and the court may, while deciding the appeal, take assistance of experienced psychologist and a medical specialist other than those whose assistance has been obtained by the board in passing the order under the said Act. That means, the court of sessions can look into an appeal against an order passed by a board of making preliminary assessment. That is something that is being laid down in the Act, which needs to be also looked into. So, in addition to these important provisions that I have talked about, there are different provisions and different chapters devoted for the cause of children in need of care and protection, such as chapter 5 talks about child welfare committee, chapter 6 talks about procedure in relation to children in need of care and protection, chapter 7 talks about rehabilitation and social reintegration, chapter 8 talks about adoption, chapter 9 talks about other offences against children, and chapter 10 is miscellaneous. Now, in the conclusion, it can be said that the most debatable and an issue that needs to be discussed is the violation of rights of the children during preliminary assessment, about which I have already talked to you. Other than that, if we look at the Juvenile Justice Act, it can be said to be one of the finest legislation that the country is having at the moment. It has brought about a paradigm shift in the approach towards looking at children. It has different positive aspects into it. Those positive aspects of the Juvenile Justice Act 2015 needs to be seen very seriously, because certain terminologies have been used which are actually grounded on the child centric approach, or giving considering the best interests of the children and things so on and so forth. And one of the, I would call it one of the most promising legislation, that is the Juvenile Justice Act of 2015, that India can proud to have, is operational in the country as a whole. And one can also identify the fact that this has been largely successful, though there are certain issues which needs kind of a nationwide deliberation, such the one that I have talked to you about, the preliminary assessment, then the fact of children's court, and so on and so forth. But as a whole, in totality, if you look at, I can definitely conclude by saying that this legislation is one of the greatest legislation, and it is actually and in real terms catering to the requirements of not only children who are in conflict with law, but children who also need care and protection very holistically and in a very comprehensive and cohesive manner. Thank you so much.